What's up? I'm Dan Fredenberg, and today I'm joined with attorney Nick Moore. How are you doing today, Nick?
I'm great. Thanks for having me on here, Dan.
Excellent, excellent. So we're going to be talking about 506B filings and some of the ins and outs of that, especially when you're remote based like me. And some attorneys make money off their advice alone, but usually the way that attorneys make money is for drafting papers and filing and interacting with other attorneys and courts on the client's behalf. So before the audience gets the benefit of your expertise, Nick, how can they help you as far as what should they go to as far as billable services?
Yeah, so what we try to do is flat fee the syndication offering documents, really in any context. Um, that allows for better underwriting. The fees are foreseeable. Occasionally, I'll have a client that says, hey, just bill it hourly, in which case our hourly rate applies. But we just try to flat fee because typically it's going to consist of the same documents throughout the process.
Yeah, that's really awesome. I can really relate because of my tech background. But let's get really down to it. So for the audience, in case you don't know, a 506B filing is when you have some sort of syndication, a business that a third party, in other words, the sponsorship group, is going to be taking care of the actual creation of profits. And that cannot be publicly advertised. If you do want to publicly advertise, it has to be a 506C filing. But the problem with that is only accredited investors, AKA millionaires, can invest into the 506C filing. So I want to get into detail in making a 506B relationship. In other words, the prior existing relationship. How can you do that remotely? So like if you are never going to actually shake hands with somebody in general, but you want to have that 506B prior existing relationship, what are some pointers that you can say?
Now, in terms of the direction that we have on sort of, virtual relationships, whether or not they're substantive enough to qualify, there is no real direction from the SEC, right? And this is a group of extremely intelligent individuals who keep the law nebulous enough to have and keep their job. Okay. And so what I recommend isn't necessarily with the advice from the SEC because they never provide that. It's just govern yourself conservatively. The SEC is abundantly clear, however, just to jump in, they're abundantly clear that the relationship cannot be born out of the solicitation of that particular security. So you can't, in that first touch, right? And we'll call them touches, okay? In this case, obviously, a virtual contact being the touch. And so if there's no excuse if it's the first time you talk to the person and you're providing offering documents and you're like sending wiring instructions for all of that, I mean, that's hands off. That's easy, right? Two touches can kind of difficult to explain yourself and say ultimately the touchstone here is it's know, like, and trust. Without getting too academic, the spirit of the Securities Act of 1933 is really to only provide that accredited investors, okay, can contribute capital in a security form, okay? Now, in a 506B, they're allowing you to have up to 35 non-accredited investors. However, the personal relationship or substantive relationship that you have, right, protects against the risk that since you don't know this person, they're not going to take you for a ride, right, or convert your capital. And so if both sides of the table can say, hey, I know, like, and trust this individual, then that is typically the hallmark. So however many touches that takes, but at least two, okay, at least two. My recommendation is three. Most of the time you're going to have contact with the person, okay? And sometimes the cadence of these conversations, you need to govern yourself this way, right? Like where you could encapsulate everything you could ever talk about and know, like, and trust somebody after the first call. You can't finish the call with an offering, and you shouldn't, right? So you govern yourself so that the second call, first is get to know you. Second is maybe more educational in sort of risk alignment, strategy alignment. And then perhaps in the third, fourth, or however long it takes. Some investors, look, not all investors are ready to just give you their money right off the bat.
Mhm,
Okay.
mhm.
Sometimes it takes a cultivating of a relationship, and those are better from an operator standpoint because you're more likely to comply with the statute. So 3 touches is a conservative approach. Make it substantive. Establish a relationship to the extent that you would feel comfortable if the person were in the next room and you weren't in there, that they would confirm that you guys had a relationship. So
Mhm,
yeah,
mhm.
receive
Yeah,
that.
that's beautiful. And so my background is in digital security and e-commerce mass marketing technology. So that means, we used to send out 5 million emails every single month for about 6 years, and that was the way that you're supposed to do it, where Google is still happy with you and Yahoo and
Of
whatever
course.
else. So one thing that I think, especially because of the IT administration and whatnot that I had to do, I think that one of the most difficult parts is documenting. And I think documenting the relationship is probably one of the most important parts, because I imagine that's what the
Totally.
SEC really has to see in order to say, it's like, okay, well, yeah.
Evidence. Yeah.
Right, evidence, great. So, so I guess the first thing to discuss then would be email list segmentation before the blast is legal. I guess the important thing is that if you do have a mass emailing system like a CRM, you have to be super careful that nobody can get into a particular list unless they have created that prior existing relationship, and then that way, you have some sort of way to communicate with them legally about your offers. Am I on the right track with this, or?
Completely. In fact, I had a conversation yesterday afternoon discussing the exact same thing,
Mhm.
right? Because naturally you're going to obtain data, right? And you're going to have these blasts, and maybe you don't know, the method by which you originated this contact. Maybe it was from an email blast or from a meetup or any kind of forum. You just never know. And so, yeah, I think it's a terrific practice, to your point, to segment and compartmentalize your emails to the extent that's your mode of outreach.
Mhm.
Okay. And say, hey, like, I know Dan F at yahoo.com. Like, that's my guy. He's over here in this bucket. And to the extent of, obviously, you can have some kind of automatic method by which you compartmentalize that would be even better. Like, hey, this person's been in our email list and has interacted with us, and maybe some sort of impressions or something like that to qualify them, because that's the ultimate purpose here, qualifying that person to support your claim or defend against a claim that there wasn't, right, a pre-existing relationship. And it's important, because if you let's be honest, in securities laws, one bad apple can absolutely ruin the bunch. You don't get the benefit of the other 67 people that you've played golf with, right?
Mhm.
That one bad actor could result in repercussions. I haven't seen anything quite that dramatic,
Mhm.
but to practice and take that conservative approach and avoiding that, you're going to be under the radar. The radar won't even come into play. You're in full compliance.
Excellent, excellent. So my next question is, what level of detail you need to know about the people in your team, their financial situation. So, like, is it sufficient to know that they have a 6-figure net worth, or like somewhere between, like, let's say 750 and 1 million, or somewhere between 1 million and 1.5 million? Like, do you have to know that level of detail, or is it more about level of sophistication and appetite for risk?
The latter, and the last thing that you said. So it's more about their appetite for risk. In a 506B, remember, a considerable amount, I don't even want to put a percentage on it necessarily, but a super majority of offerings are all accredited investors, but under a 506B, because there's a pre-existing relationship. There's
Mhm.
no third-party verification required, but you have to have the reasonable belief that they're accredited. Now, maybe in your purchaser questionnaire, okay, that's a part of your offering documents, you can have some questions in there, but it's really just it's just a goal line. Is it $1 million? Is it $200,000 a year? To the extent you want to garner additional information just to determine sort of the quality and abilities of your investor, that's a business decision.
Mhm.
In 506B, although they're not required to disclose any of their financial worth, they are required to declare that they represent and warrant that they are sophisticated, that they have reviewed, whether themselves or through a purchaser representative, like a financial advisor, somebody like that, and understand the risks that are inherent with the investment, and that they're proceeding in light and assuming that risk.
Mm-hmm.
Okay. And so, no, there's no SEC requirement to obtain that sort of information. That is more of a risk portfolio, risk appetite kind of thing. And again, that's more of a business decision. People with a fiduciary duty, like financial registered advisors and others, may have to look at that in light of their client's portfolio risk as they do their assessments early on in financial planning, if you're familiar. But in terms of a private offering, because our goal is to be exempt from the whole framework, that, you know, it's not required of us other than that bright line of the accredited investor representation that's actually filled out by the investor themselves, except with the 506C, in which the third-party verification is required.
Okay, yeah, that makes lots of sense. And now, of course, because it's gray letter law, one thing that I think is basically inevitable for a lot of real estate investors, specifically, or, you know, of course, we're just talking about capital raises, and they're all basically the same restrictions. But my question is, let's just say you did the wrong thing. You just found out, it's like, oh, you know, I publicly attempted to entice investors. It's already too late. Obviously, the typical lawyer answer would be, oh, well, you should talk to an attorney. But as far as like simpler things, like if it's on like a YouTube video, it makes sense to take it down offline as soon as you possibly can. But what should you be doing if you already screwed up like that? Like, does that mean you have to drop whatever deal you have in hand because you're just taking too much risk?
No, would be the short answer. I mean, yeah, you've incurred risk because you're not in compliance, you know, with the law. You could redeem the interest from the otherwise unqualified person, investor.
Mm-hmm.
So but you would need to put that in your offering documents. You say, hey, to the extent, because remember, we're getting a representation and warranty
Mm-hmm.
from that individual that, you know, that they comported with all of the requirements, and this is a 506B, and this is how this is established. Remember, that's more of and it's not so much an error on the part of the investor as it is the operator. I mean, historically, what's happened is you would kind of proceed at risk. I mean, the toothpaste is kind of out of the tube. I think you would want some language in your documents, and we have that to the extent they would require a registration event, which conceivably that would require. It's not that they can, it's just that would trigger a registration requirement. Now you don't qualify for the exemption. But a way that you can overcome that is to come into compliance with the exemption by the removal of that individual. Okay. And so that would be my advisement there. Listen, I've represented folks in front of the SEC. I've worked for, sorry, my wife is just inundating me with text here. So, you know, I've represented, we've all been there. You know, I've represented people in SEC. I've worked at FINRA. You know, the touchstone is really the intentionality. Mm-hmm. And that's what's punished. And to the extent that you have all your documents and you otherwise are not only substantially in compliance, but for this one particular mishap, you're in compliance. The SEC is not out here, you know, to destroy you. Mm-hmm. Okay. They're here to enforce the law as written, to interpret it based on, you know, your conduct, but really and truly intentionality. And that takes you back to Rule 10b-5 of the Securities Act, that's anti-fraud. And so long as you're not out here defrauding or purposefully offering the issuance of securities to people who do not qualify under that 506B, you should be at least able to explain yourself to the extent that they're not going to levy a ton of penalties, but they could. Right. Mm-hmm. And so your real defense against that is your ability to redeem those to avoid a registration event. And that's the language that you would use to encapsulate that issue.
Excellent.
But don't panic. Still call me, you know, and to talk it through. But don't go, you know, sell the country store. You know, you don't have to do any of that quite yet, unless I understand differently, and then I'll advise you accordingly.
Excellent, excellent. I know you got another call right now. This has been absolutely
No worries.
fantastic, you being this generous with your time. If you do have time, I would also like to ask what the process is of going from a 506B raise to a C raise. Like if there's anything that is
Hmm.
really quick that you need to keep in mind if you've already done the 506B and then you have to do the C part.
If you've run a C, if you've already done the general advertising, you have to take back all of your publication materials, wait 30 days. I haven't seen a ton of guidance on that because it's not tremendously useful in commercial real estate because of the timelines. You're not seeing that flexibility to be able to run them that way. That's more of an issue more in private equity and fund sort of contexts.
Mhm.
But ultimately, there is a way to do it. You can go 506B and then convert it conceivably to a 506C, but only where you haven't taken any non-accredited Bs, because obviously, again, one bad apple spoils the bunch. So you wouldn't actually be able to hold a 506C because an entity is an accredited investor only to the extent all of its constituent members are an accredited investor. And then if you've already got a non-accredited, then that throws a wrench in that entire program.
Wow, that's fantastic. This has been absolutely great, Nick. Thank you so much for joining me today.
Thank you. And yeah, appreciate it, Dan. Hope to connect
Awesome.
again.